Thank you, everybody, for joining us today. I'm Claire with the Autism Society of Greater New Orleans, and we're really excited to have Chip Morrison here with us today to present on planning for people with special needs. So you can go ahead and take it away, Chip.
All right. Thank you again, Claire, and thank you to the Autism Society of Greater New Orleans. We really appreciate the opportunity to put on this webinar. It's a lot of good information, a lot of very important information. Um, we're usually going to run right about 40 minutes or so, and we'll have a little session at the end for any questions, that type of thing, a little Q&A stuff. So, without further ado, let's go ahead and get started. Okay. So, as again, thank you everyone for being here, taking time out of your busy day. Um, what we're going to be discussing today is for the most part, it's going to revolve around special needs trust. We're also going to touch on a couple of different things, like a few little tricks that we use as far as what an ABLE account is. We're also going to touch on the importance of timing. And when I mean timing, what I'm referring to is parents with children with special needs. There are laws set aside a timeline if you want to maintain authority, maintain control over your child's affairs, and that's called a continuing tutorship. So we are going to touch on that. Just a little brief introduction to those of you that don't know me. I'm a board certified specialist in estate planning. All that means is this is all I do every day, all day long, is estate planning, special needs trust, probate work. Whenever someone passes away, we handle their estate, and that's all that we do here at our office. We have offices in Metairie, Louisiana, and Covington, so we can really serve the greater New Orleans area. Okay, the goal today, basically, what we want to do is dispel some myths. There's a lot of bad information on the internet, and there's some good information also, but we want to teach you and make sure everyone's aware of all the benefits that are out there and how to protect those benefits. The biggest thing we want our clients to understand, and we want anyone we do educational events for to understand, is that doing nothing is a really bad idea because that's when a lot of problems happen when parents they kind of, what is it, the ostrich that puts its head in the sand, buries its head in the sand. That's when we develop problems with how does the estate get passed on and children getting kicked off of certain programs. Okay, so what we'll do next is I want to kind of take you through a few different scenarios, and let's just get the bad stuff out of the way right off the bat. The worst thing that possibly can happen is when a parent passes away, they don't have any documentation, any estate plan in place, and more importantly, there's no one there that's already in place to take care of the child, to act as the advocate for the child. And as I mentioned a little while ago, the next problem that we see is when children lose their benefits. Yes, they can get back on SSI and Medicaid. They can do that. However, as many of you know, it's a pain in the butt to get back on SSI and get back on Medicaid. Another part of the planning is preparing the life plan for your child, and that gets missed by a lot of parents. This is our chance to say, look, these are the hobbies my child likes. I want the caregiver, once a week to take my child to go bowling or go to a painting class or something along those lines. We really want to pass on the ability to give that child truly a joyful and fulfilled life. And in the planning stages, that's our chance to do this. So, it's pretty easy. Quality of life and happiness, that is our goal here. Really, we don't do our job well unless our clients walk out of here and say, you know what, I really have peace of mind. I'm leaving here. I came here. I had no idea what I was doing. I've read so much stuff on the internet. I've heard this, I've heard that. Now I'm comfortable and I have peace of mind. That's our number one goal. All right, let's go ahead and start off with just a brief 30,000-foot view of some of the governmental benefits that are out there. Okay. As many of you know, we have to break these apart into what's called entitlement programs, and then on the other side, we have something called means tested programs. Good news is for the entitlement programs, you're good. You're golden. As long as you qualify, as long as you hit certain benchmarks, your child hits certain benchmarks, they're going to receive these entitlement programs. And it doesn't matter if you have, $10 million or $100, you're entitled to it. And the two main entitlement programs that we're talking about today are Social Security Disability and Medicare. On the flip side, well, let's take the entitlement programs one step further. Okay. As you can see on the screen, the eligibility is very straightforward for SSDI. Child has to be disabled before the age of 22. And it's based on the amount is based on the individual or their deceased or retired parents' income and net worth. Um, on the other side, you'll see Medicare. And most of us, when we think Medicare, we think, oh, okay, age 62, I qualify for Medicare. Well, here we're talking about something a little bit different. As long as you get SSDI, you're automatically qualified for Medicare. Okay. Um, it's going to cover, but the Medicare is not going to kick in until 24 months of a qualified disability. And again, this is really a very high level view. We're not going to get into the nitty gritty as far as, what are the asset tests and this and that. So we just want to make sure everyone's aware of all the different benefits that are out there. On the other side of the screen, we have what's called the means. Oops, excuse me, one second. Let's try to make this a little bit slower, smaller. Okay. So on the other side of the screen, we have what's called, whoops, the means tested programs. This is when the government or state office, they want to look at your assets. They want to look at your income. There's a bright line test that they use. And if you're, say you have over, for Medicaid, you have $25,000 in your child's bank account because your uncle was a great person and wanted to give a gift to your son who has a disability, that's going to become a problem. And the main means tested programs are, of course, SSI, so supplemental security income. Medicaid is the big one that we're worried about. In-home support services, and there's some subsidized housing issues in means tested programs. And on the bottom, you'll see the temporary aid to needy families. The two main ones that we're concerned with in our day-to-day practice area is really SSI and Medicaid, because those are the big ones. All right, I touched in the whole point of this is if you do not do the planning correctly, your child is really at risk of losing those means tested programs. And that's what we want to avoid at all costs. All right. So we talked a little bit about tutorships, being able to be in charge, remain in charge of your child's affairs after your child turns 18. Because when they turn 18, all the law knows is that, oh, well, you're an adult. You're the only one that can make medical decisions. You're the only one that can open up a bank account or write a check. In Louisiana, we have a fantastic program, and it's called a continuing tutorship. And basically, what it is, it's the path to establish incapacity in order to maintain the parental controls over the decision making of your adult child. But there's a few catches to this. Think of it this way. It's the ultimate power of attorney, a continuing tutorship. That's all it does. It is the strongest, most legally binding, effective power of attorney you could ever imagine. And just kind of take a step back, I want to make sure everyone understands, speaking of powers of attorney, if your child is eligible for a continuing tutorship, that means that their disability is at a point where they cannot sign legal documents. They cannot sign a power of attorney. So under our laws, you really only have two options. And what we want everyone to walk away today understanding is if you meet the criteria, it is incumbent on you to have this continuing tutorship done to complete it. This slide that you see on your screen is a little bit misleading. We say that a judge decides whether your special needs child will be able to maintain and take care of their own affairs by themselves. That's not 100% in the practical sense. That's not 100% of what happens. And I'm gonna touch on this in just a second. Basically, what a continuing tutorship is, it's a legal process in Louisiana. And I want to make sure everyone understands this is one of the rare instances that it's a very, there's no court hearing or anything like that. It's about as simple as a court proceeding as you can get. It is a wonderful thing to do. Um, what happens throughout the continuing tutorship is that it's the court proceeding allows all the decision making authority to be granted to another person. And 99.99% of the time it's granted to the parents. You may have heard this as a guardianship, conservatorship in other states. It all means the same thing. In Louisiana, you all know we like to do things differently, so we call it a tutorship in Louisiana. The key is it will remain in effect for your child's lifetime until, and that's a wonderful thing. However, there may be instances where your child may not need the continuing tutorship anymore. Their condition may improve where they can start making some decisions on behalf of themselves. So it can be changed. Here is, let's see, I don't know if it's this slide or the next one, but I'll go ahead and tell you right now what the court wants to see. The court wants to see a certificate from your parish coroner. So if you live in Jefferson Parish, the Jefferson Parish Coroner's Office has to sign a certificate before the court will sign off on a continuing tutorship. And so when I said a little while ago that that slide saying the judge decides, that's not accurate. Because I can assure you, anytime the petition where we ask the court to do something contains the coroner's certificate and it contains we don't really need an IEP. It helps to have that. However, what we absolutely need is a doctor's letter. And I've got to give a quick shout out to all our doctors out there, pediatricians, no matter what kind of doctors we have out there for our children with special needs. They are wonderful. They will rip this letter off in about 2 days. And I don't know if anyone's ever had any dealings with trying to get your family doctor to write a letter for school or something like that. It usually takes them 3 weeks to get around to doing it. All of the cases I've been involved with in continuing tutorships, I'm telling you, it's amazing. The doctors will knock this thing out in a matter of a day. So we're really, really proud of our doctors. Um, what we do is we prepare a form and it just says, Judge, here's the deal. My child has XYZ condition. My child has trouble communicating. My child cannot manage their own affairs. My child cannot handle money, cannot go to the grocery store, doesn't know how to, can't make medical decisions, things like that. Both parents have to sign off on this. That is really, really important. If one parent cannot sign off on it, then we need to state in the petition. And unfortunately, that happens. We just say, Judge, the father is, he has a substance abuse issue. He's not been in the child's life for 15 years, 16 years. And the courts are pretty good about understanding that type of scenario. But the biggest one is at the bottom where the coroner has to sign that certificate saying, I agree. And I can tell you, once the coroner signs off on it, you're good to go. The judge is going to sign off on it. You'll see my tip at the bottom. Please allow yourself plenty of time to start this process because it does take a little while. It takes a few months to get the whole thing done, and that's just because we have to wait for the coroner, wait for the judge, that kind of stuff. So let's go through the timeline because this is going to be the most important thing, one of the most important things you're going to hear today. Here's our key. Between the ages of 15 and 18, that means that once the child turns 18, it's over. You cannot do it anymore, okay? So I'm trying to be nice, but we really have to be stern with our clients. The child's 17 and their birthday is going to be in 2 months, and we tell the clients, hey, you need to get on this right away. If you don't get this information back to me in 1 week or 2 weeks, I am not going to be able to do this for you. Then you're going to have to go to an interdiction proceeding, which is a lot worse. So, what's our sweet spot? I think 16 years old is the best time to do this. Yes, a lot of parents wait till 17, and that's okay. 17's fine, early in their 17th year. But I think 16 years old, that's when you need to be jumping up and down saying, hey, I remember some lawyer told me something about 16 years old. I got to get something done. That's when you want to go see your lawyer. What the court really wants to see, or what the coroner's office really wants to see before they sign off on this, is that the doctor's letter has, and this is our magic language, the last bullet point, the doctor's letter has to say that the child possesses less than 2/3 of the average mental ability, average mental functioning of children of the same age. So that is our key. What we do for our clients is the easiest thing in the world. We just email them, dear client, here's the magic language for the doctor, and we put it in, red lettering. Clients just print out the email, bring it to your doctor, and the doctors know what to do. Okay? So what happens if you don't get the continuing tutorship done before the child turns 18? Well, unfortunately, we have to go through door number two, which is the not so fun one. That's where we have to go through the full interdiction proceeding, where you have to go to court. The court appoints an attorney to interview your child. It gets to be really, really expensive, and everything at that point is up to the judge. Continuing tutorships, really, it's up to the coroner's office, and the judge signs off. Interdictions, that's only up to the judge. Interdictions are a lot more expensive. Let's try to avoid that at all costs, okay? All right. We have a pretty cool thing on our website. We have a bunch of brochures, pamphlets that we give out to clients. And this is just gives you an idea of a family with special needs, what their timelines are. What should they be doing before the child turns 14? What should they be doing before the child turns 18? And what can they do, or what are their only options after a child turns 18? Um, the big one is we want our families to have their estate plan done. And I'm going to show you how important that is and why that's so important in Louisiana in just a second. And I hope everyone can see the QR code. I think you can take a picture with it with your phone and be able to download it. And I'll just give everyone a second because it's really a fantastic resource for everyone. All right, let's go into our other planning options. What's easy? Yeah, well, before we do that, before we tell you what we see that works really well, let's go and take a look at what does not work well at all, okay? And the big one is do not give money away. Please, we're begging you, don't give money away. Don't give the child's money away. If Uncle Joe left the child 25,000, don't just immediately take that money and give it, to his sister to hold for the child. Please don't do that. Disclaiming an inheritance or a gift. Someone gives money, someone leaves in a will. Uncle Joe's will left $100,000 to Susie. Susie has special needs and is on Medicaid and SSI. Please do not automatically say, well, then we're just gonna, we don't want that inheritance. Because what you're doing when you do that in the eyes of Medicaid is you're making a gift because it has that 100,000 that was going to go to Susie, that has to go to someone else. So Susie's just made a gift of 100,000 and now she's going to get punished by the state Medicaid office. So we want to make sure that everyone understands these are not recommended. We just talked about disinheriting. We like to joke. The other planning option that we do not recommend is the hope and pray plan. And we're going to show you some of the major problems. And a lot of parents think the same thing. Look, I've got my oldest daughter is a fantastic person. She's a CPA, great kid, does all the right things, very responsible. I'm just going to leave everything to her and she's going to take care of Jimmy. Jimmy has special needs. We're going to show you in a second why that doesn't count. Spin down. Many of you, if you've done any research on Medicaid, yeah, spin down is absolutely an option as long as if it's on qualified expenses and things of that nature. There's another really cool thing we can do in Louisiana, well, all states now, is what's called an ABLE account. You can set up a bank account at your bank for your child. And this is called the ABLE account, or I think it's a 529A plan. If you ever see that, it all means the same thing. However, ABLE accounts are limited on what you can give to that account, how you can fund that account. And for this year, 2025, you're limited to only contributing $19,000 into an ABLE account in any given year. And of course, our final planning option, which is the best option that we want all parents to do, is a special needs trust for your child. We went through disinheriting already. And I'll show you in Louisiana, it simply doesn't work in Louisiana. You're going to run into a ton of problems doing this. And I think that's going to be our next slide. Yes. All right. We're a little different here. Man, different's a good thing sometimes. In Louisiana, we are the only state in the country that has something called forced heirship. And what our law does is it says if you meet these two criteria, your parents cannot disinherit you. Your parents have to leave you a portion of their estate. Until 1996, your parents had to leave you 100% of their estate, believe it or not. So who is a forced heir? Any child, if the parent passes away and any child is under the age of 24, meaning they have not reached their 24th birthday at the time of their parent's death, they are a forced heir. There's no ifs, ands, or buts about it. They have to get their 1/4 percentage of their parents' estate. The other type of forced heir is a child of a decedent who has a physical or mental incapacity where they cannot manage their own affairs. They are a forced heir no matter how old that child is. So If the child is 35 years old when the parent dies and the child has, Down syndrome and it's a pretty severe case, they're going to be a forced heir. They have to receive a portion of their parents' estate. And there are some exceptions out there that will allow a grandchild to qualify as a forced heir. Basically, if the parent was under 24 at the time of the grandparent's death, then the children of the parent will be a forced heir. Okay. As I may have alluded to, if you have one child that's a forced heir, your will or your trust has to leave that child 25% of your estate. If you have two or more forced heirs, the forced portion is capped at 50% of your estate. All right, this is the big one that I want to just spend a little bit of time on because this is the one that we see most often with clients, and everyone's intentions are good, and we understand that 100%. But what a lot of parents do is they say, well, let's go back to, my oldest daughter. She's a CPA in Nashville, and, she has a great relationship with her son. I know she's going to take care of my son. I know it. She loves that child to the bottom of her heart. The problem is that, what if daughter who's a CPA has a bum for a husband? What if she has a she gets fed up with her husband and they end up getting divorced? And the parent leaves, that leaves the all the estate 100% to their daughter. Well, guess what? And they know that daughter is going to take care of their son. Well, guess what? If the daughter and the bum husband get in a divorce, there is a really good chance that half of that inheritance is going to walk away with the no good husband. So we really have to be careful for this. Same thing if, what if the CPA daughter gets sued for malpractice and they take a big judgment against the daughter, the creditors do, and all of a sudden, even though we know that money was only to be used for our son with a disability, creditor doesn't care. They're going to seize that whole account. So we really have to be careful for in these types of situations. You see on your screen the upside of doing that. There's no loss of benefits for the child. But in this case, I would say the risk greatly outweigh the reward. Spin down's another option. We do this, a lot. Yeah, and you have to take this in context, though. If we're talking about, $500,000, you're not spending down $500,000. We're talking about 50, 40, $50,000, something like that. Yeah, we can spend that down. We can do improvements to the child's home. We can put some of the money in an ABLE account. Basically, what we want to do is make sure that child only has no more than $2,000 in their bank account. Pay down debts, purchase goods and services, a new refrigerator, things of that nature. And if you spend it down correctly, your child will still be able to keep their qualification for Medicaid and all governmental assistance benefits. We just kind of went through the upside, I guess. They can maintain the benefits. Um, Downside is, kind of goes without saying. Once you spend it, it's gone. There's no money for care after that. All right, ABLE accounts. This is a fun one. We like ABLE accounts. We're big fans. However, yeah, the two bad things about them. Number one, you're limited on how much you can put into that account. $19,000 per year right now. And at the child's death, if there's any money left in the ABLE account, shoop, it gets swiped right out and goes back to the state of Louisiana. So that's the downside to ABLE accounts. All right. On the screen, we have some of the qualifying disability expenses that you're allowed to pay for in ABLE accounts. There's a lot of things you can pay for. We haven't in our practice, we really haven't seen any problems on how you use the funds held in an Enable account. There's some definitely tax benefits. The income from an Able account grows tax free. That's probably the biggest thing mom and dad are concerned about. Of course, when you make a gift to an Able account, it's a gift tax free event. You don't have to file a gift tax return. So that's really neat. A few other benefits to the beneficiary. It gives your child a sense of control, a sense of, hey, I've got my own bank account. So that's pretty neat also. And it's easy to access the money. You just write a check or debit card, whatever the case may be. All right. This is where the real, the real meat of the presentation is, and that's when we're going to talk about special needs trust. So whenever we're talking about a trust, we need to understand that there's really three parties to this dance. There's a trustor or a settlor that we call in Louisiana. They're just the person who creates the trust. Then you have a trustee. That's the person who is in charge of the trust, kind of like a manager. And of course, you have the beneficiary, and that's going to be your child with special needs. So there's a lot of control left with the parents when they create special needs trusts, especially if they do it the right way. Some side benefits, if you create a special needs trust and you really think about who you want to be in control, how you want the funds in the trust to be distributed or spent on, you can really oversee the inheritance. We in Louisiana, what we're talking about, we have a rule against controlling property from the grave. This is the exception to that. A trust is the only way you can control property that you leave to other people from the grave. The best way, I think, to think of a special needs trust, think of it as a supplemental needs trust. It's there for one purpose, to supplement your child's life. Um, as you can see on the screen, the benefits are fantastic when a special needs trust is properly drawn up, protects assets, maintain government benefits, all that good stuff. And the unfortunate thing that we see every now and again as lawyers, we get cases that get sent to us on a big listserv email, and it's from all the different courts around the state. And every now and again, we get the really heartbreaker case where we see it and you just get mad, your face turns red, and everyone, gets up in arms about it. When someone takes advantage of a child with special needs, someone takes advantage of an underage child using their money, it's basically theft. If you do the special needs trust correctly, you're going to prevent that because you are picking the people that are going to control your child's inheritance. Another beauty of special needs trusts, it's very, very easy for others to contribute to it. And there is no contribution limit. You can contribute $100 million to a special needs trust. It doesn't matter. So it's really, really a powerful tool that we use in the context of estate planning with children with special needs. Um, if it's done correctly, and if it's done as what's called a third party special needs trust, the beauty of this thing, when your child passes away, we do not have to pay back the state of Louisiana. That is a very powerful technique. What if your child gets sued? They're a little bit older in life and they cause an accident or they do something and they get sued. Well, I'm here to tell you today, no creditors will ever touch the assets held in a special needs trust. Same thing with the continuity of management. You're going to have, I'm going to be in control of this trust for the rest of my life for my child. When I pass away, my niece Sally is going to be in control. If Sally cannot manage this trust, Jimmy's going to manage this trust. And we go on, you know, go 3 or 4 people, and that's usually sufficient. So that works out well. Um, and again, we have the lifelong advocacy assurance at the bottom bullet point. What we're talking about there is we want to build in some life care planning in there as far as, you know, these are my instructions to you. This is what my son likes to do. Once a month, I want you to take him to a movie. Once a month, I want you to teach him something new, a new task, a new skill. So you really get some control in there. The only special needs trust that we're concerned about it for the purposes of this conversation are a first party and a third party. The two that you see on the bottom, I've never done. I'm very familiar with a pooled special needs trust. We just don't do them here in our practice. All right, so let's go ahead and knock out first party special needs trust. This is in case of emergency only. What a first party special needs trust is, the assets that are made up that make up the trust that are used to fund this trust are the beneficiary's own assets. What does that mean? If your child was in a car wreck and they are now disabled for the rest of their life, they have a severe disability, we can still create a special needs trust after the car accident. But the jury, when the jury says, I give Joey 100,000 or $1 million, that was always Joey's money. And the only way we can create the special needs trust is what's called the first party trust. And the bad thing is it has to be irrevocable, which means you cannot change it. Once you sign on a dotted line, you cannot change that trust. Second thing, you have to pay back the state once your child passes away. Whatever's left in the trust, if it has $50,000 left in it, it has to pay that $50,000 back to the state of Louisiana. This is the trust that we want our clients to do. This is the vast majority of special needs trusts we perform in our office. Third party special needs trust. It simply means it's funded. The money that's inside the trust, the property that's inside the trust, would belong to someone other than your child, other than the beneficiary. This is great. These third-party special needs trusts, we make them all revocable, meaning if you picked your sister as the backup trustee in case you can't be in charge of it one day, and 5 years from now, you and your sister have a big falling out, you can change it. You simply change the trust and say, I hereby name my cousin as the manager of this trust. You can have different types of beneficiaries in third-party special needs trust. The biggest thing with these is that when the child passes away, the beneficiary passes away, we do not have to pay back the state. So that is a very powerful planning technique. All right. So who's going to be the manager of this? What kind of things do we want to look for? Well, number one, we want a pretty strong advocate. We want someone that's going to stand up and have some backbone. And if we get wind of, just say your child's living in a community type home, and Susie caregiver is trying to influence your child in any way, we want the trustee to say, hey, I'm on to you. I know what you're doing. And I'm making sure that I am paying vendors directly instead of sending money to the home to buy or not snacks, but to buy certain things for the child. We're going to send the money to the vendor directly. Accountability. You need to have a trustee. If you pick a trustee, the manager, they need to be accountable for their actions. What does that mean? Simply, they need to keep good records. They need to keep copies of the bank accounts. Doesn't mean that they have to have a CPA license and this and that. No, they just have to keep good records. They have to be financially savvy. They don't have to be the world's greatest investor, but they have to know that, look, it would be a really bad idea if I invested 100,000 out into trust into Enron that was a total fraud. We need someone with some good sense of financial or good financial sense if they're going to manage our trust. All right, there's a lot of do's and don'ts with special needs trust. The big ones are that we see problems with is something called food, clothing, and shelter. These are the really, clothing. I can tell you, we don't see a lot of issues with clothing. We see issues paying apartment rent, condo rent. That's where we see, the state coming in and say, no, 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 you violated the rules, or a check being written to Winn-Dixie every month. That's going to be an issue. That's what that whopping, I know it makes no sense, but that whopping $800 a month your child gets from the state or SSI, that's what that's supposed to pay for. But how it works is we take the government money, the SSI money, we pay for all, the food, clothing, and shelter with that money. The special needs trust pays for everything else, a new refrigerator, transportation. To make this even more confusing to you guys, yeah, a special needs trust can't pay for shelter, but a special needs trust can own a home. That's our government for you. Another issue we see, trustees commingling trust assets with their own. We want to make sure that we avoid this. There's going to be problems if that happens. And you'll see, I believe it should be on your right-hand side of the screen. Those are all the dues, what you can spend money for. Hobbies are a great thing. I tell clients, hey, I want you to go wild. If your child likes painting or bowling or whatever, go wild on that stuff. All right. All special needs trust, really the biggest thing, guys, is that it has to last for the beneficiary's lifetime. That's the big takeaway I want everyone to walk out of here understanding. We can't just say this trust is for you until you turn 65 years old. It has to be for the child's lifetime. Um, Again, these are just some bullet points on as far as, do you need a special needs trust or not? If you answer, depending on your answer to these questions, well then yeah, your child probably does need a special needs trust. Really, the second bullet point, if you answer yes to that, your child needs a special needs trust. All righty. These life events here, those are different things, throughout the years of being in this practice area where we see clients, their uncles give money to their children, that kind of stuff, or personal injury event. These are all things that will arise in someone's life where they will need a special needs trust. All righty. I always hesitate before I get into the income taxation on special needs trust because we can really get into the weeds. Basically, I want to boil it down. If it is a third party revocable special needs trust, the parents simply pay any income taxes on it. Not a big deal because it's generally not going to incur any income taxes. It's when the parent passes away, then the trust itself has to pay the income taxes. Everything, look at the bottom bullet point, everything has to be coordinated with the estate plan, though. So your will has to leave the property to a special needs trust. Your will just can't say, well, I'm going to leave everything. I created the special needs trust. I'm good. I'm going to leave everything to my other daughter, Sally, in Nashville. It has to match. A few misconceptions that we hear a lot from our client. Well, I'm not a multimillionaire. I don't need a trust. That is not the case at all. In fact, if you're a multimillionaire, you probably don't need a trust because you can self-fund your child's care. Um, a lot of parents say, "Well, my child's only 4 years old. He's too young. I don't need to do the planning yet." I would argue to the contrary. That's probably the most important time you do need to do the planning so you can pick Who is going to be the guardian of your child? Who's going to raise your child? Those types of things. All right. So as you can see on a screen, whenever we ask people, who do you think needs to do this type of planning? The bottom line is everyone needs to do this type of planning. If you have a child who's an SSI recipient or one day will likely be an SSI recipient, if you have a child of a disabled parent, a non-disabled spouse, everyone in these categories needs to do the estate planning. We just kind of have the little question on the screen. It's a lack of knowledge. And I'm going to show you in just 1 second. Why do people fail to plan? It's not intentional. It's just we don't know what we don't know. A lot of parents feel overwhelmed. If you have a child with special needs, it's tough. You have a lot of things on your plate. And what do we do when sometimes we start feeling overwhelmed? Our natural reaction is to shut down, or what's the saying, fight or flight. Unfortunately, a lot of people just shut down and they try to forget about it and not think about it. We can't do that in these situations. And as I said a little while ago, you don't know what you don't know. So hopefully after today's presentation, you will all know what a special needs trust, what are some of the issues you guys face out there. It wasn't, I said the ostrich in the sand, but we have a funny picture of the man sticking his head in the sand. The problem doesn't get any better if you wait. Waiting doesn't solve anything when we're dealing with planning wise. Um, and as you can see, a lot of the impacts, if you do not do the planning and if you don't do the planning properly, meaning you use the computer AI generated forms, it doesn't work in Louisiana. So these are the things that we want to watch out for. All right, another QR code. We have a really cool special needs trust bundle, planning bundle for you on our website. If you hit the QR code with your phone, it'll pull it right up. If the QR code is not working for any reason, let us know. We'll need to fix it and we'll get the information to you. We have a ton of information on our website, morrisonlawplc.com, and everyone is free to call us. Everyone is free to ask us questions, set up an interview with us, a consultation. Of course, our consultations are complimentary for children with families with special needs. And I'm hoping everyone knows what complimentary means, right? It's free. So please give us a call. That's what we're here for. We're here to help. And again, if you don't leave our office with peace of mind, I've done something wrong. Okay? All right, let's go ahead and take some questions. Oops.
Hey Chip, there are some questions in the chat. I've been trying to keep up with them. The first question got asked really early when you were talking about just like the means tested, not means tested programs. Somebody was asking if you guys have any experience with the OCDD waiver programs through the Human Services Authorities. If you guys have any experience interacting with those programs.
I don't. The only thing I'm aware of is the now waiver. And, just from what I understand, get on the list as early as possible.
Yeah, it's actually not a wait list anymore. Jonathan, who asked that question, I know a little bit about the waiver program. So if you want to send me an email, I'd be happy to set up a time to talk to you about it.
That's fantastic. I am tickled to hear that. That is excellent news.
Yeah, it's need based now. So
Yeah.
they
Oh,
can't work
wow.
differently.
That's excellent.
That's
Yeah, we that's just not in our wheelhouse.
the next question we have, and Latanya, if you want to unmute yourself and just ask your question directly, you can. Um, she is asking, she's from Virginia, and in Virginia, their interdictions and stuff are called guardianships, and she
Mhm.
wants to know if they would have to reestablish that in Louisiana if they moved here.
Oh, you're going to love this, Tanya. It's real easy. I had a guy, one of my clients when I was doing business law a few years ago. He moved to Louisiana from Houston. He had a child with severe special needs. a severe disability, it's really easy. If they enter the guardianship in Houston, it's a judgment. And what happens is I just take that judgment and I go to the judge in St. Tammany and say, hey, judge, this was the court's judgment in Houston. Everything's correct. We get this certified copy. It's got to be a special certified copy. I don't know how. Anyway, the judge in Louisiana in St. Tammany, they're great. They said everything's good to go. It is now official in Louisiana.
Thank you so much. Do you know if it matters if he is now 20? We got the guardianship when he was 18.
Doesn't matter.
Oh, you just made me so happy. Thank you so much.
Okay, let me see. Yes, I am sending out the recording after. I did, Adrian, you were asking about the QR code. I put the direct link to that bundle in the chat. So for anybody who had trouble scanning that QR code, I did put the link in the chat and I will email it out as well. We have a question asking if the special needs trust can be named as the beneficiary of your 401k.
It should be. Yes. Do not name your child as the beneficiary of your IRA, 401k, life insurance. It's gonna mess up. It's gonna be an issue. Name the special needs trust as the beneficiary. Great question. And this is a really good time for everyone to take a quick look at your retirement plans at work or whatever. Make sure you have, make sure who your beneficiaries are.
Let's see. The next question we have is someone asking what happens if there's no people available to like control and run a special needs trust? Like if all the people die or something like that.
The what the courts will appoint, they can appoint a trustee to act on behalf of the trust. It may not be what you want. So what we do, the bigger question, the question should, well, the solution here is any special needs trust, you should have a procedure to pick a final trustee. So you can say, I hereby, if I name my son and my daughter to be the trustee of their brother's trust, if nobody wants to serve or can serve as trustee, then I hereby name my CPA John Jones to pick a final trustee. But the court, if that didn't happen, the court can in fact pick a final trustee. They do a pretty good job. I will say they do a pretty good job. Most of the time, they're going to pick a bank to be the trustee. The good news, the bank's going to do the right thing. Bad news, they're going to charge the max fee of like 1%, 1.5%, or something like that a year.
The next question, I'm just going to read it verbatim so I don't like mess anything up. She says, my mom's will says that if I predecease her, my son's share of the inheritance from her would be put in a special needs trust for him. If I also make a will to create a special needs trust, can he have two special needs trusts or would they be combined somehow?
Okay, my mom's will says if I predecease her, my son's share of the. Uh, on this one, we can combine the special needs trust. Yes, it would be two special needs trusts. That's why. So everyone, just take a second. The way we like to do it is to prevent this problem. We're going to go ahead and create your special needs trust. This is going to be the holding bucket right here. You're still going to have your will done, and your will is going to be easy breezy and just say, I hereby leave my, if you want to leave everything to your child with the special needs, I hereby leave all my property to the special needs trust. Since this special needs trust already exists, if mom wanted to, or say grandma wanted to do that also for the child, all grandma has to do is say, I hereby leave $100,000 to Jim's special needs trust. You see what I mean? So that we want to have the holding vehicle then everybody's wills all around can name that trust as the beneficiary. So you only have one trust. To answer the question, yes, they can be combined. It's a little bit of a thing that we have to do on the legal side, but they can be combined.
Someone asks, can the special needs trust be set up to dispose of any funds that may be left in the trust after the child dies?
Oh, absolutely. Well, they have to be. Yeah, they have. Yeah, they are. Yeah, and most parents with children with special needs, they'll leave everything in the trust. If the child passes away, and if there's any money left over in the trust, it goes to brother and sister. That's 99% of it of the way it goes. Yeah, but there has to be a procedure for what happens to the funds left in the trust when the child passes away. And guys, all we're talking about, we say trust and all this, all we're talking about is a bucket. That's all it is. It's just a bucket holding the assets.
Let's see. We have one chat question, and then I see someone with their hand up. The chat question, who would the beneficiary contact if the parent passes and they need help getting the process started? I guess the process of like the whole like will stuff, like who would be
Mhm.
contacted to start that process?
It would be the parent would have to, the parent's will should name an executor. Um, that person is going to be the really in charge of everything. All the parents out there, it's a really good idea if you do your planning, make sure your executor, make sure your power of attorney knows that, hey, look, I've got everything taken care of. Jimmy, you've been my neighbor for 20 years. I've asked, in my will, I'm asking that you be my executor. All my documents are located under my stairs in a big green binder. You don't have to tell them all the ins and outs. It is a good idea to let the person know who you chosen as your executor. All my documents are located here, so that if something happens, and this can be a family member, of course, if something happens, we know where to look.
Adrian, I see you have your hand up if you'd like to unmute and ask your question.
Hi. Yeah, my daughter was recently in a car accident. I put in the chat, and she had a concussion, and they're assessing like what all needs to be done. But yeah, how do settlements work if they get something from the insurance company? You would put that into a trust? So I just don't know how it works exactly, if you don't mind.
Yeah. So that's going to be what's called a first party special needs trust. You would create the first party special needs trust. Then your personal injury attorney is going to contact the insurance defense attorney. And he's going to say, look, this money cannot be paid to daughter because she's going to get kicked off all these programs. However, we want the settlement check to be paid to, the special needs trust. You remember the bad trust I talked about, the first part? I shouldn't say bad, the not ideal one, the first party special needs trust. That's the type of trust we're talking about here. She'll still be able to receive Medicaid and all that good stuff, and but the proceeds from the whatever the settlement is will be paid to the trust. Um, there's going to be another issue on that one called Medicaid set aside, something like that. I'm not real familiar with the personal injury aspects of Medicaid, but I just want you to be aware. So don't get too upset when you find out that a part of it has to be set aside for Medicaid. So
Okay, okay.
yeah.
Well, thanks for the heads up.
Let's see. I also see a hand up from Priscilla if you'd like to ask your question.
Hi. So I just had a question related to the last question. So you were saying, if if the beneficiary received a settlement, it would go into that first party trust.
Correct.
Can you have a first party and a third party at the same time? Like, because
Mhm.
I'm assuming, you said the third party is the ideal one to create for like will estate planning purposes.
Yes, we have a situation where we have it happens more frequently than you think, where there's an inheritance. Someone died with a parent died without a will, or grandparent died without a will. The inheritance has to be held through a first party special needs trust. A few years later, parent creates a third party special needs trust, or whoever creates it. Those two different kinds of trust cannot be merged because there's
Okay.
different rules. First party, you have to pay back to state when the child passes away. Third party, you don't have to pay back to state. But yes,
Okay.
we do it unfortunately quite frequently.
Okay, great. Thank you.
All right. We are just right after 1 o'clock. Looks like all the questions have slowed down. I just really want to thank Chip again and all of you for being here and being
Yeah.
so engaged. And if you have any questions for Chip, his phone number, their phone number for the office is right there. If you have other questions that are not like related to the specifics of special needs trust or able accounts or things like that, feel free to reach out to the Autism Society, and I would be happy to try to help you out.
All right. Thank you, everyone. Everyone have a great day. Thank you, Claire. This was a great crowd. Thank you, guys.